Next, from Chicago, we go one-on-one with Tanya Solov, director of the Illinois Securities Department. We'll hear what investors should know before they invest with a stockbroker or financial planner, and what should children of elderly parents be doing to keep their parents from becoming victims of investment fraud. This runs about 35 minutes.
Tanya Solov, you're the director of the Illinois Securities Department, and it's part of the Secretary of State's office, but I think it's a department that a lot of people in the state of Illinois probably never really heard of, or even if they have, maybe aren't quite sure what it is you do. Before we get into some of the details, give us an overview. What is your department, what is your mission, and how many people do you have working for you, and what parts of the state?
The Illinois Securities Department is part of the Office of the Secretary of State. We have an office in Chicago and Springfield, but of course we cover the entire state of Illinois area. Our primary mission is to regulate those individuals and those companies who offer and sell securities in Illinois or offer investment advice. In addition to regulating these entities, we also help investors who may have been the victim of investment fraud.
Now, when you say you regulate the people you just mentioned, it sounds like would that be limited to stockbrokers, or would that include financial planners? Just who would it entail?
Well, anyone who offers or sells securities in Illinois should be registered. So these individuals may be registered with broker-dealers. Common ones might be Edward Jones, Morgan Stanley, Merrill Lynch. These are names that we heard of. So these individuals selling in Illinois have to be registered. Also, individuals who offer investment advice have to be registered as investment advisors if they have assets under management of under $100 million here. Companies that sell securities, if they're not otherwise exempt, would also have to file with us.
Now, let's say somebody is thinking of going to a financial planner. What should they be doing relative to the information your office provides to maybe do their homework and check out, first of all, if that person is a legitimate financial advisor, if they've registered with your office?
Well, the term financial advisor, financial planner, investment advisor representative, all those terms are really used pretty loosely today in today's world and investing world. If someone is going to get investment advice, or if they want to buy or sell securities, they would be going to individuals who should be registered with our department. And prior to conducting business with anyone or giving any money to an advisor or a stockbroker, the best thing to do is to call the Securities Department or visit our website, or you can Google broker check and get information as to whether or not that individual is registered. Because many of the frauds we encounter in our department, they're conducted by individuals who are not registered. They're not registered with a broker-dealer, they're not registered with an investment advisor, they're just out there selling investments or offering securities.
If somebody is registered, what kind of information would we find if we looked up? Would we just see that they're registered, or would we have some idea? Would we look at their record? Would we be able to see if complaints were filed against them, or what kind of information is contained?
Well, there's quite a bit of information that's available to investors. Certainly whether or not the individual is registered, their employer is available, so you could see their employment history. If they have had significant arbitration actions against them, that information is available. What may not be available is whether or not there's a pending complaint, because it's unresolved, so that information is not posted. However, in cases where our department in particular takes an action against an individual, if we take an official action, that will be posted on our website, because we may issue a notice of hearing or some sort of temporary order of prohibition. We do post our orders on the website. Certainly if someone types an individual's name in Google, if we've posted an order, that would come up.
When somebody has engaged in some kind of fraudulent acts, what kind of fraudulent acts does your department come across? Give us just some examples.
Okay, well, they vary. With regard to individuals who are registered stockbrokers, some of the more common complaints involve suitability, that whatever investment was sold to the investor was not suitable. And this often arises if the investor is a senior citizen or an individual who is not looking for a high-risk investment. So a risky investment sold to an individual who is looking for low risk would be a suitability complaint. Another common complaint is that there was a misrepresentation, that the broker misrepresented some aspect of the investment. For example, it may be that the investment is a very long-term investment. It's difficult to liquidate it, it's difficult to sell, or the charges for selling it are quite high. So, omissions, misrepresentations are common complaints. And then unauthorized trading is another complaint we sometimes get with registered brokers, that I never authorized that transaction. I didn't tell my broker to buy that stock, or he sold it without authorization. So those are the most common complaints that we receive with regard to registered individuals. Now, with regard to unregistered individuals, common complaints are fraud, that the misrepresentations occurred, the money is gone, I can't find the person, I didn't receive the promised rate of return. And those are the common ones we get. And often they involve promissory notes, that somebody issues a promissory note for some sort of business, or startup business, and alternative energy is a very popular one now. Con artists tend to follow the headlines. So if the headlines are discussing how important alternative green energy is, we can be sure that there are con artists out there claiming that they have, wind companies, or they have solar companies, or oil and gas drilling, any kind of alternative company. Even with the hurricanes, we issued a warning saying we're certain something will pop up where a company says we have, restoration services, we clean water. When the oil spill occurred off the Gulf course, we had a con artist who said, I'm going to breed bacteria that will gobble up the oil. So whatever is in the news.
And he sought investors for that?
Correct. And they're often very convincing, these individuals, because they may give you documents. They may even set up a website and say, just go to my website. You'll see all the financials there. The most important thing we tell individuals is look for red flags and call our department to make sure the individual is registered to offer or sell securities.
Now, we covered two different kinds. One is a legitimate business, and maybe there's a complaint against someone who has been a financial advisor and is registered. The other, as you mentioned, is a complaint against an individual who has not registered. What recourse? Let's take the recourse. If you feel that you've been injured financially, what is the recourse, first of all, with someone who has not registered with your department? Is there any recourse for the individual to get their money back?
Well, for individuals who are not registered with our department, if they offered investment advice or sold securities, they still fall under our jurisdiction. So our department will probably charge them with, number one, failure to register, and number two, we will look to see if there was fraud. So if they took the investor money and they promised that they, for example, would invest it in some real estate project that they would rehab and there'd be a 20% return, but instead of putting it into the real estate, they put it towards a yacht for themselves or gambling debts. In those cases, we would charge violations of our anti-fraud provisions. If there's any money left, if it hasn't all been spent, at the casino or on personal items, then we have conducted forfeiture actions where we take the money that's left and we will do a pro rata distribution to the investors. Now, often there is no money left because by the time the investors complain to us, it's at that period of time that they realize they can't get a hold of the person, or the individual, the con artist, fesses up, oh, sorry, I spent all your money. So by the time the complaints come in many cases, the money is already spent, and the best we could do is refer the case for a criminal prosecution. In some instances, though, we've been able to recover some money, and then there is a pro rata distribution, although it's almost never 100% on the dollar.
Yeah, we see that even nationally, the Bernie Madoff case. Here was an individual that his reputation was golden. I believe he was at one point the head of the NASDAQ, and yet it turned out that he himself was a scam artist, and those that he scammed, which again included very smart and influential people, are getting pennies back on the dollar. Now, if you've been ripped off by someone who is as Madoff was, a registered agent, just because they're registered doesn't mean that they're not a scam artist. Is there any additional recourse, or is it the same thing? In other words, if they were working for XYZ brokerage company, is the brokerage company liable for damages that their agent brought to customers?
The brokerage company, probably in most instances, will be liable because that individual acted as an agent of the broker. Now, from time to time, and there have been a few court decisions where the courts have said, you know, the activity that the broker engaged in was so fraudulent and he took such measures to hide it from the firm that they wouldn't have found out about the activity even if they did a reasonable audit or inspection of the firm. So in rare cases, broker's activity was really so far outside of the firm and hidden that the brokerage firm was not found liable. In a majority of our cases, though, the brokerage firm has accepted responsibility. And that's another reason to invest with a registered entity, because often the individual representative, the salesperson, is not going to be able to reimburse you if he puts you in an investment that failed. Usually they don't have enough money. But a brokerage firm will generally, you know, if there is a legitimate claim there, will in fact offer some rescission or form of remedy to the investor.
Now, relative to the assets of your department, do you have enough? I mean, I guess someone brings a complaint. I would imagine your department investigates it to some extent, right?
Yes, we actually, we get about 500 complaints per year and we investigate all of them. Sometimes they're pretty easy to solve. You know, there was a misunderstanding or the brokerage firm says, okay, we'll make the investor whole. Some cases do take much longer. So we have a staff of attorneys, investigators, sworn agents, and examiners and auditors. We have currently just over 50 individuals working these various cases, in addition to licensing and reviewing license applications and registration applications.
And I think you said off the top you have an office in Chicago and one in the Springfield area?
Correct.
If someone is living in Carbondale or something, I mean, do they call the local office? Would that be in Springfield? Or, I mean, is it geographically determined, or is it assigned to the different offices based upon what kind of an infraction it is?
Well, we work all the cases together, and often what happens is if somebody in Carbondale was defrauded, it probably crossed other areas too. And depending on the case, it may be worked out of the Springfield office or out of the Chicago office. If a senior citizen is involved and it's difficult for them to bring their documents to, for example, from Carbondale even to Springfield, our investigators do go out, especially if we're involved in a case involving seniors, and we can interview individuals at their home. We can photocopy their documents there, because people usually don't want to give up their originals.
Right.
So we would take the copies, and documentation is very important. We tell individuals to please keep all the documentation you receive. Open your statements. Sometimes we find that people are afraid to open their brokerage statements because they say, oh, it's only going to be bad news. But it's very important to open all the statements from the broker and to try to complain as quickly as possible if you believe that you've been the victim of some kind of wrongdoing.
And you mentioned, because one of the levels of complaint is that somebody has sold something that you didn't authorize. And if you don't open your statement, you would not therefore know that they sold something. If you do open your statement, you might see that they had sold 3,000 shares of ABC stock, and you could follow up and first call and question why that was done against your when you didn't authorize it.
Yes, that's actually a very good example. And what happens when you don't open your statement for a while and it piles up because you're going to look at all of them at the end of the year, the firm has a pretty good argument that you've ratified the transaction. It's much more difficult to allege that somebody didn't authorize something if a significant period of time has expired from the time of the transaction.
That's a good point. Now let's say, let's use the term statute of limitations, which is a legal term, but while there may or may not be an actual statute of limitations on how long they can complain, at what point does your office say, Mrs. Smith, you really waited too long? I mean, do they have to make a complaint within the first 3 months, 6 months? within a year? Where do you draw the line and say, I'm sorry, you've really waited too long to bring a charge against this person?
Well, in our statute, there's a 3-year statute of limitations, and that could be extended for an additional 2 years if the fraud was effectively hidden from the investor. What becomes difficult is trying to get all the documentation if an individual waits that long. So we will take the complaint. We don't say, oh, this is too long, because we really investigate whether or not there was additional communication after the time of sale. Because we've had cases where somebody invested 5 years ago or 7 years ago, and they continue to get statements. Now, they were fraudulent statements, but they continue to get promises and statements and saying, okay, well, your investment has come due. Is it okay if I roll it over? And they say, oh, looks like we're doing fine. Go ahead and roll it over.
Which is exactly what Bernie Madoff was doing.
Right. So if there has been some communication and it looks like there is a rollover of the investment, we don't always construe that 3-year period or that 5-year period that strictly, because that kind of communication opens up a new time period for investors. But again, the longer investors wait, sometimes witnesses disappear, people's memories fade, it's more difficult to get bank records for us, so it's better to complain promptly.
What about a dollar amount? Do you say, don't bother us if you've been defrauded for $1.50? Where's the dollar amount that you say, okay, we're going to take this on?
No, we actually don't say that we have a dollar amount. There are dollar amounts if we're referring cases for criminal prosecution. I mean, it's hard to get a federal or even a state prosecutor to take a case if somebody was defrauded out of $220, just because they have to prioritize.
I guess they could take it to small claims court, could they not?
Well, most people cannot, because if you're with a broker-dealer, in opening that account, you probably had to sign an arbitration agreement. So virtually every broker-dealer requires customers who have a complaint. If you're not going to complain to the Securities Department, you want to pursue it on your own, you have to go through arbitration. And that arbitration is with FINRA, the Financial Industry Regulatory Authority. So that's what most investors would have to do, is they would have to go through FINRA. The reason we take and look at small cases is because while it may be a $29.99 charge you should not have incurred, that may be a practice of the firm. And so it didn't impact just that one complaining investor, but it may have impacted every investor in the state of Illinois who was charged that $29.99. And that's why we
So it could be millions of dollars,
Correct.
even though each individual investor was nickel and dimed.
Exactly. And that's why we do look at even the small dollar amounts, because it may be a practice that the firm should not be engaging in.
My friends on the trial bar, and we happen to be meeting here during the mid-year meeting of the Illinois Bar Association, would say that's why you want trial lawyers to bring those class action lawsuits. When you just mentioned, and it is true, when you sign up for some brokerage, for virtually any brokerage house, you're going to have to agree, it's almost by duress, because you really don't have a choice if you want to sign the agreement, that you're going to go through arbitration. But at what point then can an individual, if the arbitrator rules against the investor, does the investor have any recourse? Can they bring civil action if they're convinced that they've been defrauded?
Well, they can try, but a vast majority of case law says that the arbitrator's decision and the arbitration is final. I have actually seen very few arbitrations reviewed and reversed. So basically, that's going to happen. If you go to arbitration and you lose, that's probably the end of the line. And it is a problem. And I've testified and written letters on this. I really think that mandatory arbitration is not great for investors. I think once the dispute arises, if the investor and the brokerage firm would like to go to arbitration, that should certainly be an option. But to force the investor to sign an arbitration agreement pre-dispute, I think it is a problem for investors. And there really is no choice, because every brokerage firm requires it. When arbitration was first, mandatory pre-dispute arbitration was first upheld in the 1980s, there were very few firms who had that provision. And so the court said, well, if you don't want to go to arbitration, go to a different brokerage firm. But now that every brokerage firm has that provision, there really is no choice for the investor.
You know, virtually every doctor, probably every doctor, would carry malpractice insurance. Are those who work within the financial industry, are they required, or do they as a practice carry some form of malpractice insurance so that if there is a judgment, the investor would have some funds that they could go after and not just be getting a portion of whatever monies could be scrounged up from shoe boxes and closets?
Yes, they do carry insurance. It's not a requirement that we have at our department or in our rules or regulations, but I think it is a practice that the brokerage firms engage in, because I've gotten complaints that it's very expensive to carry that kind of insurance. I've seen some instances where insurance companies don't want to cover certain actions. For example, I saw one recently where we're pursuing a claim against a broker-dealer, and I saw that the insurance company said, well, if you get a regulatory action against you, we're not going to cover it. So I actually encourage broker-dealers to be sure that they're adequately insured.
If you had to narrow down, I'm sure there's a long laundry list of things you would change if you had the power to change them, but first of all, let's say, as far as advising investors themselves, what are some of the primary things? We've touched on some. Open the account, but how long should they keep the records? To what extent, you may find, as an example from your experience, that people who tried that they were defrauded maybe just didn't have the documentation to back up their charge. Or maybe they said, I verbally told my broker I didn't want to go into anything that was risky. How do we know, and let's take that kind of an example, how do we know who's right? Because you might have someone who lost money and then cries wolf after the fact that, oh, I was put into something that was too risky, and maybe they were all gung-ho to get into that, but then maybe it wasn't the broker's fault. Maybe it's just the investor who's trying to recoup some money by claiming they were defrauded when they really weren't.
Right, that's true. So we have a burden of proving by a preponderance of the evidence that the broker violated a provision in our statute. The way we conduct an investigation is we get the investor's documents, we get the investor's side of the story, we also get documents from the broker and the broker's side of the story. A vast majority of our cases involving registered brokers actually settle, because if you look at the documents, with the suitability cases, we can pretty much ask the investor, okay, if you're a senior citizen and you were put in a investment at the age of 77 that comes due 30 years from now, that probably wasn't suitable. So sometimes on the face of the documentation and just the nature of the investment, we can say there was a violation, a suitability violation. So we do evaluate that, and we have the burden of proving the case. As I indicated, with most registered cases, the firms settle with the investor. In cases where the con artist, I will call them, is not registered, those are generally just outright fraud cases. It's not about suitability, it's just about it's about lying to the investor or misappropriating the funds. And those kind of investigations, we often have to get the bank records. That's why we tell the investor, never pay in cash. If you have a check and they show us the check, we can at least look at the back of the check, see where it was deposited, look to see who else deposited in there, where the money went from the bank account. So there are some tips we give investors. Never invest cash. Don't be pressured into investing right away. If somebody says you have to invest now or you're going to give up the opportunity to make a lot of money, it's going to be too late tomorrow or the day after, I would stay away from that investment because you shouldn't be pressured into that. If the promised rate of return is significantly higher than what everybody else is getting in the marketplace, that's another red flag for investors that this may not be a legitimate investment, because getting a 20% return these days is not reasonable. It's not likely. It's probably not going to happen. So we say if there's a promised rate of return that's high, or if the investment is absolutely guaranteed, because we see that in some of the con artists. This is guaranteed. You're going to get 30%. This is risk-free. Those three statements alone should be the statements that tell the investor just walk away from that investment. And we tell investors, don't invest in something you don't understand. And maybe if you feel...
Yeah, but isn't that, I mean, the general population, I mean, on one hand, that sounds like wise advice, but in practicality, I would say I'm a fairly financially literate person. But in talking, I talk to people who are otherwise very well educated, doctors, lawyers, and they reflect most of the people of the United States. Most people are financial illiterates. And so most people don't know, they don't understand anything they're in. If you ask most people what is an ETF, which is a fairly basic thing to understand, they won't know.
Well, what we tell investors is you should try to educate yourself a little bit on what that is. And it is important to ask the broker some questions. And that's why you should invest with a registered broker, because if it turns out that that ETF was not suitable for you, there will be some recourse. Brokerage firms also have to field complaints. They generally don't want to, go to arbitration, and most brokers really are pretty honest. Bernie Madoff was a huge problem. It got a lot of publicity. But most brokers, if you think about how many brokers are registered and how many enforcement actions we have, they are pretty honest. I mean, they don't want to do the wrong thing for their client. They want to put them into something suitable. They don't want the complaints.
No, first of all, I would agree with you. Most people are, like most people in life, are honest, and they want to do a good job servicing their client. They want to grow their business, and they're not going to grow it by developing a bad reputation with people. They want to get that word of mouth. So, just like everyone, I want to lay that out. How many enforcement actions do you take in the course of a year on average?
We take about 200 enforcement actions.
And when you think about the whole state and all the
Right.
transactions that go on throughout the course of a year, which must be, I would guess, millions, that's very small.
Right.
Not that you necessarily know of all, I'm sorry, not that you necessarily know of all the infractions that are out there, but still it's a small number.
Right, and what we're seeing are more and more actions involving actually unregistered brokers or private placements.
There's one aspect, and we've talked a lot about a number of different things. One thing I'm curious about, sometimes there might be people who are violating the law and they are violating the rules and they don't know it. They're not meaning to defraud anybody. If I say I want to go into the real estate investment, or I want to go into buying a piece of rental property and fix it up, and I go to 5 of my buddies and say, would you each chip in 10 grand and I'll pay you back within a year 20%. And I'm sincere that I think I can do that. Do I have to register with your office, or is that just a deal among friends?
Well, it gets very complicated because with regard to registration, there are often exemptions that occur. So for example, if your buddies make over $200,000 a year, they're exempt. They're not even counted as investors. We also try to make it easy for people to start small businesses. So there are some filings that are very minimal filings. So you would really have to take a look at the statute and think about, well, how many people am I soliciting? Am I soliciting anybody generally? And I will say there will be some changes in the law coming, because federally the Jobs Act was passed earlier this year, and the SEC is going to write rules to make it easier for small businesses to solicit investors. So we're awaiting that, because that will also impact how capital raising occurs in the state. But basically, with any investment, what we're looking for is for the individual who is running the investment not to defraud people. We understand that legitimate businesses sometimes fail because of market conditions or something that's not under the control of the proprietor of the business. However, these individuals can control, are they telling investors the truth? Are they spending the money the way they said they would in their offering documents? So that's what we look for. Certainly we don't just take enforcement actions against, businesses that fail and it was through really no fraud at all.
No fault of their own.
Right.
And I would tell people, look, there's always a level of risk. If you buy government bonds, there's a level of risk. The bonds the entity, if it's a municipality, could go bankrupt. Or just by virtue of the fact, if inflation came back and you have your money tied up in a bond that's paying you 1% and inflation comes at 5%, you're losing money. So there's always going to be a risk, even on things like bonds are typically viewed as a very low risk investment option, and typically they are. But nothing, virtually nothing is no risk. Lastly, if you find someone has defrauded people and it was a pretty blatant case, again, you're not the Attorney General's office, you're the Secretary of State's office. Do you refer cases to the Attorney General's office for prosecution, or do you refer them to the local county prosecutor? How is that handled if you think maybe a criminal action?
Well, we've worked with 3 different sets of prosecutors. If the case crosses county lines, and sometimes it even crosses state lines,
Sure.
In those instances, we generally work with the U.S. Attorney's Office. And we've worked with every U.S. attorney from the Southern District, Central District, Rockford office, Chicago office, depending on where we might have maybe the greatest concentration of investors. We have also worked cases with the Attorney General's office. We've done forfeiture cases with the Attorney General. And if the fraud involved just one county, for example, we had a fraud involving just individuals in Cook County, we've also worked with the Cook County State's Attorney's Office. So in those kinds of instances, and especially if the case involved many senior citizens, or sometimes it's affinity fraud. It's targeted at a particular group. We had a fraud in the Hispanic community. We sometimes have frauds in particular church communities. So those kind of cases, we have had pretty good success in getting some prosecutor to because it also, it not only sends a message to people who might want to get into the fraud business, but also it's an educational piece for other individuals in those particular affinity groups or communities.
This is we could go on and on and on, and we can only cover so much at one time. But I would caution people that as the baby boom generation ages, we are going to have the largest generation of elderly people ever. And one of the particular classes of fraud is of those who maybe when they were younger would never have fallen for a scam, but as they age, they become more susceptible to being frauded. And so I think children ought to be watching out for their parents or grandparents and discussing that. Would you agree, as they go along, to kind of make sure that grandmas or even their parents, their financial assets are where they are and how those are being invested or being shared by some of the younger members of the family who can just keep tabs on them?
Yes, you're absolutely right. One of the reasons senior citizens are targeted is because they generally have some money. Younger individuals are still working, slightly older younger individuals are paying off school loans or maybe mortgages. But senior citizens tend to just have more money, and so they're targeted for that reason. Secondly, there have been a number of studies conducted that show senior citizens often tend to be more trusting. And they have this sense of reciprocity. So if they go to a dinner seminar and somebody gives them a nice free dinner and then says, come see me for individual investment advice, they feel obligated to do that. Also, with regard to finances, it's very interesting, but I think in our culture, people don't really want to talk about how much money they have. They'd sooner talk about a surgery they had than about how much money is in their bank account or
especially
where they're
old
invested.
people.
Right. But we do encourage senior citizens not to be embarrassed, because as you indicated earlier, we have had businessmen, lawyers are common targets of fraud, and accountants too. So there's really nothing that embarrassing about it. The reason we call people con artists is because they're very good at gaining the confidence of people. And we do urge children, older children, to watch out for their parents and to ask about finances and to discuss it. They tell parents who have young kids, you should start talking to your children about saving and about the value of the dollar. We encourage that conversation to also occur with the sandwich generation, which is kind of the middle-aged generation, with their parents.
All right, well, Tanya Solov with the Illinois Securities Department, you're the director, and we thank you for joining us. We can look forward to following up with you on some of these other topics, because not only financial literacy is important, but being careful. I mean, it only takes a short amount of time to lose a lifetime of savings, and I think it's important that people are wary. Let me squeeze in one last question. If I go to one of these seminars and I ask, are you a registered financial advisor? And the person says, yes, I am. Is there some quick way that we can check to make sure they're not just lying to us?
Well, I think the quickest way is to come home and either go to our website where you can get some telephone information and call us, or really go to broker check. If you have access to a computer, type in broker check in Google.
Is that brokercheck.com or what is that?
Just if you type in broker check, it'll take you to the FINRA website, because FINRA runs the broker check program. Or
And then you can search by the individual's name.
Correct, by the individual's
And that would tell what? That they're registered?
where they're registered, how they're registered, and whether or not they have a disciplinary history.
Okay. Well,
Don't
again,
believe all the certificates you might see. You should really call, because we've run into instances where people pass around, certain designations or certificates. Somebody had a business card that had the acronym for high school graduate. All kinds of fancy letters behind a name does not mean that they're registered to do business in this state.
All right. Well, all good advice. Thank you again for joining us.
Thank you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.